you are very well aware, we are recording these sessions. So the CLE is being recorded. If you don't want to be on camera, now's the time to hop off. Otherwise, please smile and we will be recording this. My name is Alexandra Kleinfeld. I'm the co-chair of the ADR practice section together with Ann Dalton. And I'm a certified circuit, family and county mediator. I'm also a qualified arbitrator. And we are very pleased that we have Joseph Coleman today to represent to us. Joseph is very well respected in this community. He's a graduate of the Florida State University College of Law. He graduated in 2015, and he is also a Florida Bar Board certified business litigation attorney. So he did his homework, so it's very impressive. Joey also currently practices commercial litigation and intellectual property litigation at his firm, Coleman Litigation. He is also currently president of the Young Lawyers section of the Lee County Bar Association, chair of the Collier County Trial Law section, a governor of the Young Lawyers division of the Florida Bar, representing the 20th Judicial Circuit, and chair of entertainment, arts, and sports law section of the Florida Bar. I have no idea how you do that, but that's awesome. Joey has also been recognized with the AV preeminent rating from Martin Hubble, has been named a Super Lawyers Rising Star, and has been listed as one of Naples Illustrated's top commercial litigators for multiple years. So very well versed, and we are looking forward to hearing from Joey about mediating commercial disputes. And having said all of that, the floor is yours, Joey. Thank you so much.
Well, thank you so much, Alexandra, and thank you all for participating this afternoon. And I do mean that in participation. So if you have a question, please put in the chat. And if not, I'll leave some time for questions. As Alexandra said, my name is Joey Coleman. I practice commercial litigation throughout Southwest Florida, both in Collier and in Lee County, throughout the 20th Judicial Circuit, but primarily in those two counties. And this is not my first rodeo in terms of mediation. I think that December, as I always tell some of my colleagues, is the best month. If you've got a case, especially a commercial litigation case, I'm imploring all of my clients to at least kick the tires and try to send a settlement proposal or try to prepare for mediations, because as we see a lot of times, specifically in commercial and civil litigation disputes, we find more cases resolving in December than we do throughout the rest of the year. That's at least based on anecdotal evidence. Why? There's a lot of different reasons for that. Hey, the books are closing if you're a business. A lot of people don't want to drag the cases off into 2025. So I think this presentation is extremely timely for the month that it's happening. So I'm going to take a minute and share my screen. And like I said, we're going to talk a little bit this afternoon about mediating commercial litigation disputes. So let's see here. Okay, so let's talk a little bit about what we're going to explore today. First, what is a commercial dispute? How is it different from other disputes that might be mediated or litigated? For example, family law or personal injury, some of those types of disputes that we see specifically with general practitioners. Preparing for a mediation involving one or more commercial parties, attending that mediation and concluding the mediation either with a resolution or an impasse. So first, what is a commercial dispute? Well, it usually is a dispute involving a business or business tort, such as a breach of contract, etc. A commercial dispute and doing commercial litigation doesn't necessarily require a business, right? There could be two parties involved in a commercial dispute. They have a small business. They have a contract, they have a loan. That's still something, touching on business or touching on a business tort, touching on a breach of contract, etc. It usually does not include family law, personal injury, but as discussed, that can be cases that involve business torts and disputes. For example, a family law dispute may involve a defamation claim, which we see pretty routinely in commercial litigation, or a breach of a promissory note between the parties. So there are aspects of commercial disputes that can touch on those other areas, and those areas such as family law or personal injury can sometimes touch on things that may more ordinarily be packaged in to a commercial litigation proceeding. So how are commercial disputes different from other disputes? Well, there's a variety of different ways that those can be different. For example, they can be, but they're not always as emotionally involved, meaning the client may not be as emotionally invested in the case. We find this more and more, at least I do in my experience, more and more with the larger that the company is. So it's important to keep that in mind, right? If your client is either an individual or a small business, right? A closely held LLC, maybe they're the only partner, maybe they're the only principal, maybe there's one or two principal, right? It's a very small company. If you have an individual or a small company, this may still be an emotionally charged proceeding, even though it involves a commercial litigation dispute. When you get to a larger company, right, especially when you look at insurance companies or other companies that
We might have lost you.
that nature where they have adjusters come down.
Okay, you're breaking off, Joey. I don't know if you can hear me. Okay, it looks like he has some technical difficulties. Apologies for that. So let's see if he is logging back on.
Well, I apologize for that. There seemed to have been a minor technical difficulty, but I wanted to take that. That's a great point, actually, to talk about dealing with technical difficulties, including in mediation with Zoom. Right now, I'm on a backup. There was an issue with my Wi-Fi. I had a personal mobile hotspot that's working, and it's very good. So you always want to test the connection if you're doing a mediation via Zoom, regardless if it's with commercial litigation parties or any parties. We're in the new day and age after COVID, and we're doing a lot of things, technologically. It's important that you test your connectivity, you test it on your, and you always have some kind of backup. And if your client's not in the room with you, and this is more likely in commercial litigation disputes, you want to make sure to test their connection as well, right? You want to do that usually before the mediation occurs. But if you've got a client who's a corporation, they can't come in, you want to check in with them the day before, make sure that they're available, make sure that they know the mediation is going to be coming up. And you also want to get on a Zoom with them, make sure that they understand how Zoom works, or whatever other audiovisual platform you're using. And you want to make sure that connection is as strong as it possibly can be. So I think this is coming through great now. Alexandra, can you hear me? Can you hear me okay?
Yes, perfect. I appreciate the live experience.
Of course, I'm glad to give everybody kind of a taste of what it could really be like sometimes. Let me go back to sharing my screen.
Thank you.
Of course. So we were talking a little bit about how commercial disputes are different from other disputes, and basically the emotional, how parties can be emotionally charged or not emotionally charged in these types of cases. Adjusters, again, not really emotionally charged, but it is important to discuss this case with your client. Really, the A word, authority. Who has authority? What is the adjuster? If there is an adjuster, what can they tell you about, the value or how they see the value of the case? And the other word is the C word. Communicate, communicate, communicate. Talk to your client about what is this case really about. It may surprise you. And keep, Alexandra and I were talking about this right before the CLE, keep checking in with your client because there might be differences. Maybe the time of year reflects how their goals and objectives have changed. Maybe over time, the litigation has become protracted. Things have happened. They've lost emotion. They've lost a hearing. Their deposition occurred. Those goals and objectives and motivations that they have may change, even if they're a corporation, right? The company's attorney, if they have insurance, might be having different discussions with the adjuster based on things that have happened in a case. Cases aren't static. I like to tell clients in litigation is like a puzzle that moves or a puzzle that fights back, right? And so the piece of the puzzle that was in the middle before might now be on the end of the frame or vice versa. So it continually moves throughout the process. Litigation is not static. Your client is not static. Their motivations, goals, and objectives can change, not only based on what's happening, in their particular case, but also just basically facts and circumstances on the ground. Maybe as we talked about before, it's December. A lot of companies are closing their books. A lot of people want to have litigation resolved. A lot of people want to start litigation though, right? And so it's important to always check in with your clients and understand, what is this case really about? What are their goals and objectives? I always go back to, and I tell my colleagues, when I'm giving this example, I always like to go back to the story. One of my first clients that I had, we were in a commercial litigation dispute over basically a potential construction defect involving like an HVAC system. And we were basically getting ready for our second mediation of the case, and trial was pretty much, on our doorstep. And I asked the client, said, well, let's just check in. What were your goals and motivations? Like, what are you trying to get out of this process? And the client said, well, I just didn't want my company to get sued. And I thought to myself, well, it was a compulsory counterclaim that the other side had to file, right? It was just non-payment versus a construction defect. And my point was, you guaranteed that they were going to sue you by filing this lawsuit. And so it's important to, like I said, always check in with your clients. Not only your client might have great claims, right? They might have, $1 million claim or $100,000 claim. They might have, you might feel so good about the case, but it's not about you. It's always about back to the client. Who do we have that fiduciary obligation to? If our client wants to settle for a handshake and a ham sandwich, we have to make that offer, and we have to try to resolve it on those situations and on that, because that's what it's really about. Making the client satisfied and trying to do the best we can for the client. And that goes back to listening and communicating to the client. And that can be more difficult. Sometimes it can be easier, but it can also be more difficult when we're talking about commercial litigation, right? It can be easier because they're going to be a lot more transparent, right? It might be a lot more dollars and cents. Joey, I want $100,000. Joey, I want, an indemnification from this thing that's going to be occurring. Joey, I want a release from, as it relates to, any claims that could be brought, between the parties and we're having some disputes about the release. They might be a lot more transparent, but it's also harder because, it might be really goes back to the authority. Not only does the company have the authority to settle, but are you talking to the person who is actually making the decisions for the company, who's actually going to be able to discuss with you and say, these are the goals and motivations my company has and why. So talking a little bit more about how your client may be different, or how the other party's client may be different, right? You may be representing the individual against the business where there's a breach of contract claim or where there's a defamation or tortious interference claim, right? You're in a commercial dispute. So how might their client or your client in a commercial litigation process be different? Well, if it's a company, they may be much more sophisticated with litigation than, for example, a spouse going through their first lawsuit and divorce. They may be, don't have to be, but they may be much more involved in the legal process. This might not even be their only lawsuit, right? So it's important to recognize that and to talk to your client about their previous experiences in litigation. And they may bring their own experiences in the litigation, including their prior wins and their prior losses. So if a company has lost, that might make your job easier, or might make your job more complicated, right? Because if the company's won a series of their other claims, they might be more entrenched in their position. They might say, no, you don't understand. This is what happens. We always win these cases. But if a company has lost several different claims, or has more of a mixed bag, so to speak, right? They've won cases that they should have lost and lost cases that they should have won. And that's going to be more likely to be the case if the company has been in litigation for a long period of time. They might be able to understand, appreciate, and truly internalize the risk as they understand it to be, because they may have not actually prevailed before. It is hard to walk a client through their first loss. It is hard to walk a client through the first time they've lost in court on a motion for summary judgment or a jury trial that hasn't gone their way. It's very, very difficult. Even if you explain it, it's hard for them to internalize it. Right? It is just hard for us to truly understand that, especially if we feel like we're going to be right. You can try as hard as you can, and you can explain that and persuade your client, and sometimes you'll be able to do that. But if a client brings those experiences into litigation, it's important to recognize, is that something that's happened in the past before? And then kind of basically leaning in and really exploring those experiences. How did that make the company feel? What did the company have to do and pivot as a result? How confident did the client and the company feel going into that litigation? Is that the same level of confidence they now have, right? They might better understand those risks. And especially the larger the company is, the more likely they're going to understand and be able to take those risks into consideration. How they've estimated that risk, right, is what's going to cause that delta between the offers that your client makes as maybe the plaintiff, or the offers that the opposing party makes as the defendant in mediation. So, and it's easier in those situations to talk to the client about the obvious but also hidden costs of litigation if they're a company. So the obvious costs for anybody in any litigation is the attorney's fees and costs. They're paying attorneys. Attorneys are expensive, right? They're going to spend that money on a third-party expert to basically advocate for their position, and they're going to spend that money that they could be spending in other places. And the potential downside if the client doesn't prevail, especially if you represent the defendant. What happens if you don't prevail in this? Not only may you be responsible for the other party's attorney's fees and costs, but the other potential downside is not only may you not have an even result, but you may actually have to pay them money. And that's just important to recognize that your client is repeatedly, hearing that, even in commercial litigation dispute. But there's also, and it's different than you see in, like, for example, perhaps family law or maybe personal injury, is the opportunity cost of it all, right? The client may lose more money devoting their time and resources towards the lawsuit than they could have resolving it. And the client may make more money resolving the case and instead investing their time and their effort into other endeavors. If you think about it, if you represent a company in a dispute, those principals of that company, no matter how small, have other things they could be doing with their time. They have other investments they could be making with their time, with their effort, with their energy. There's a real cost to that. I always go back to one of my favorite anecdotes. I was trying to resolve a breach of contract dispute with a realtor. I represented like a homeowners association or quasi homeowners association. There was just basically a breach of contract dispute with this realtor. And the realtor went on and said, I can't believe I'm talking to you right now. I could be, selling a house rather than dealing with this. And I said, you could be selling a house? He said, yeah, I could be selling a house. I don't know why I'm still talking to you. I said, okay. And what would the commission on the house be? He's like, oh, the commission would be, $50,000 or $100,000. I said, okay, well, what my clients are requesting here is less than what you would make off that commission that you would otherwise make if you weren't talking to me right now. So I'm going to keep talking to you, but if you want to resolve this, you're going to make more money resolving this with me and going to get that deal and getting that commission than you would if you, prevail in this lawsuit. And that actually really hit home for him, I think. And we resolved the case as a result. I was representing the plaintiff in that case, and I think he made a really smart financial decision. It's important to recognize not only, again, the obvious cost of litigation, but the opportunity cost that your client or the other party is going to potentially incur if they continue with this litigation. It's one of the things I always usually bring up at the end of mediation. I do an opening, and usually at the end I talk about, I don't know what your opportunity costs are, right? I'm not your client, but there are specific potential business downsides to continuing on with this litigation. You may have some deal that's going to detract from your principals dealing with this, and not every day, right? But through a deposition, through responding to discovery, through being in this mediation, through having your principal or one of your agents be at trial, there's going to be a cost to that. They could be doing something else with their time. Is what they could be doing else with their time a better use of your resources? Like, is that going to potentially bring in more money? Because again, it's commercial. So there might be, like, they need to really understand, maybe there's an economic, effect to that. Maybe there's not, but that's something that needs to be discussed with them, and something for you to consider when you're preparing for mediation with a commercial entity or in a commercial dispute. And something I've talked about, from the beginning, and I'll continue to talk about, is insurance, right? Insurance may be involved. Your client or the opposing party may have some insurance coverage to handle all or some of the dispute. And I think it's very important to recognize in commercial litigation disputes, there is a particular sort of statute on point that sometimes allows you to request insurance information from the opposing party. Basically say, look, there's a claim and I would like to get a copy of your insurance policies. Or if you are in litigation, or if you're in litigation, through discovery. We have the rules of civil procedure are being amended effective January 1st, 2025. We are now going to have mandatory discovery or mandatory disclosure like we do in federal courts. Many times in federal courts, when we're doing mandatory disclosure, one of the things that have to be produced without even a request is whether or not there might be insurance to cover all or some of the dispute. There are some benefits and there's some drawbacks to bringing on insurance, to making a claim. But usually if I'm making a third party claim, meaning I'm making a claim against the other party's insurance carrier, there's very little downside to my client. There might be some, as we'll kind of discuss a little bit further, but it's definitely something I'm going to discuss with my client. And I almost always, one of the first couple things I'm sending to my client, besides the engagement agreement, the preservation of demand or preservation of evidence letter, and then the demand letter to the other opposing party, is I'm always asking myself, do I want their insurance information? Even if I don't, my client decides not to file a claim, do I want to have a copy of the coverage? Do I want to understand what the insurance coverage's position has been? Like, right? How has the insurance responded to that? Have they potentially declined to cover the claim that I'm making against their client if I'm the plaintiff? What is the insurance position, if any? Maybe they don't have insurance. That's something also to understand, because they might have a added incentive to come to a resolution. I have a case right now where the opposing party has admitted they don't have insurance. Well, there's some drawbacks to that, but there's also a benefit, because it's important to recognize that there's not somebody else who's going to be financing the litigation, and who's, they might have an added incentive to come to a resolution because they're coming out of pocket for all of this. Doesn't seem like there's a different avenue of recovery there. So it's important to recognize, like I said, in commercial litigation, how are the parties different? What are their goals and objectives? What are their experiences? And really to talk to your client, if this is one of your first, or not even your first, just any commercial litigation dispute that you've had, it's important to just really kind of talk to your client, communicate with them, and really discuss this, especially throughout the process, but definitely before mediation. So preparing for mediation, you have a mediation coming up. How are you going to prepare, and how is that perhaps similar or different than other mediations that you've been a part of? Well, like in any other mediation, I've been saying it before, the C word: communicate, communicate, communicate. Listen to your client. What are their goals, their motivations, their fears, their risks, their downsides, right? It's important to recognize not only what do they want, but what are they really trying to avoid? Is it increased exposure from the litigation? Is it protracted litigation and paying more of your attorney's fees? Is it, what is it about this case that they're both trying to get out of it, and what are they trying to necessarily avoid? And back to authority. If you're speaking with a company, your client now, maybe for the first time ever, or, this is a new company for you and new change in management. But if you're speaking with a company, make sure you're talking to the agent or representative with actual authority to resolve the dispute, and the person who will be attending mediation on behalf of the company. Traditionally, especially in closely held businesses or smaller businesses, mom and pop LLCs, maybe there's one or two people part of the company, they're probably going to be the same person, right? It's probably going to be the same one person you've been talking to throughout the litigation, who's got authority to resolve the dispute on behalf of the company, who's going to be attending mediation. You can kind of check all of those boxes if it's a smaller company, but again, that's something you need to discuss with the company beforehand. But it's important, sometimes that's not the case, right? Who you've been talking to back and forth is not the person that the company is going to send to mediation. You have to make sure, if it's a company, that they have authority to resolve the dispute, that they don't have to basically say, hey, we're going to go to mediation. Bob's on vacation. and I can't get in touch with Bob, and Bob's the one who's going to be able to settle the case. That might be sanctionable behavior because your client, the company, is not engaging in good faith at mediation. And then you want to be able to nip that in the bud and resolve that to the extent possible before mediation. So you truly want to understand on behalf of your client, who am I going to be speaking with on mediation? Who is attending? Do they have authority? Is this the same person I've been talking to? If it's not, why not? And has the person I've been speaking to, the agent or representative on behalf of the company, have they been talking to the person who's now going to be resolving the dispute? Do they understand? Are we all keyed in with each other and we understand what the goals and motivations are? Because that slows things down, right? If you now have a representative at mediation who hasn't been familiar with the day-to-day aspects of the dispute and they haven't spoken about the case, that might slow down trying to make this as efficient and an effective process as possible, because they're going to be trying to figure out between each other, hey, what did we talk about? Why is this offer being made? Why are they so upset? What does this portion of the claim mean? You want to kind of, nobody is going to expect everybody to have perfect information and remember the case and have it memorized by the time they get to mediation, but those conversations need to be happening in the background. And I think it's not only important, the last point on the slide, it's not only important to make sure that your client, you're talking to the person with your client, the interested stakeholder who has the ability to resolve the dispute. It's also important on behalf of the opposing party. And one of the ways to do that, check in with opposing counsel if they have it, and make sure that they're filing the requisite paperwork with the court to determine who is going to have authority prior to mediation. They need to be filing the requisite paperwork with the court to say, this is the person who's going to have authority to resolve this case on behalf of that client. So you don't necessarily have, again, perfect information going in, but you're not basically caught in the dark when somebody shows up and you've never heard of them before, especially if it's a smaller company, right? If you have person A and person B of the smaller company and your client's pursuing litigation with them, and you've been dealing with person A the whole time, you want to know going into mediation, if it's a company, that person A is going to be the one who has authority and is going to be attending mediation. If not, and they say person B, well, that's something I want to call opposing counsel about and say, hey, we've been dealing with the person signing your interrogatory responses and the person we deposed is person A. And now you're telling me person B is showing up on behalf of your company. Is there a particular reason why? They don't necessarily have to tell you, but maybe they will, right? And sometimes that's a good thing and sometimes that's a bad thing. Sometimes if you have, a closely held company and there's one or two individuals, maybe they're trying to do a good cop, bad cop, or maybe they have delegated out those rights and responsibilities in the company. Maybe there's somebody who's been answering all the interrogatories, but maybe the second person has not, is just there to try to get it resolved. If that's the case, I might change my mediation strategy. I might change my opening, right? If I've been dealing, I see the interrogatory responses and I know what I've done in deposition, and I've been dealing with principal A the entire time, and now I see a week before mediation, principal B is going to be there. I may say to myself in my opening, I need to spend a lot more time on the facts. I need to spend a lot more time explaining the litigation to the new principal for the company, because they're not the person who's been signing everything. They're not the person, at least to the extent that I'm aware of, right? I've been doing discovery, and that's the principal that's been doing discovery in this case. So I can't assume that principal B, the other person who's now been named to attend mediation, knows exactly what's happening. So I might spend a little bit more time kind of educating them, more than I would normally do, educating them on the claim and what matters here. So some things to keep in mind, again, for preparing for mediation. Like any mediation, I think it's important to draft a mediation summary and prepare your opening. And to share your summary and your thoughts on your opening with your client beforehand, so you can make sure you and the client are on the same page. I think that's extremely important, because how your client chooses to respond, sometimes I have clients who say thumbs up. That sounds great. I love what you're doing. I have other times that clients, take a giant red line. They say, I have a lot of thoughts and I want to share them with you, right? And we discuss that. Maybe their thoughts aren't appropriate for mediation. Maybe they are, right? You want to basically make sure that you are in a position where after the opening, you go into the first caucus with your client. You say, how did we do? And they say, we did great. You got all the points that I wanted you to get across. That's kind of the goal there, right? One of the goals. both in terms of educating the case, educating the mediator, educating the opposing party, and also, talking to your client and saying, like, have we accomplished what your objectives were for the opening? And were those objectives realistic, right? Was it, if you said, oh, I really wanted to get under their skin, doesn't really make a lot of sense, especially in a commercial litigation dispute, because that's not really something that it's not usually effective anyway, inflaming the passions in an opening. But it also is really ineffective if you're dealing with an adjuster. They're not gonna, there's no passions to be inflamed, right? They're looking at this from the value of the economic picture. They're not, maybe as the empathy, the appeal to empathy or the appeal to feeling may really kind of fall on deaf ears. And that's another reason to discuss that with your client beforehand. Maybe you're the one who doesn't represent the commercial litigation client. So you want to basically say, you want to discuss it with them, and you want to say, here's my goals, here's my strategy, here's my opening, here's my summary. What do you think? And, you want to really just key in with them what they're trying to do and what they're trying to accomplish, and make sure that those objectives are reasonable. So first, in preparing for the mediation, draft that mediation summary and prepare your opening. Then the second, what is the status of that insurance? We've been talking about it before, right? Before preparing for mediation, what's the status, and making sure you understand that picture. Have they declined coverage? Have they accepted coverage? Are you dealing with a carrier? Have they told you in filings that they prepared for the mediation? Have they told you who the adjuster is going to be showing up? Those are all the things that you can kind of know. And if the status of insurance is declination, right? They've rejected insurance coverage for this dispute and the other side has coverage. That's something to also bring up. Maybe that declination of insurance was wrong. And that's something maybe the two of you now are really kind of ganging up on their insurance carrier and saying, they rejected insurance and really maybe they're the bad actor here, right? And you don't, you're not going to get a peek behind the full curtain here, but if they decline coverage, you're entitled to get that information, or typically I've gotten that information. If I say, I'd like your insurance information, and my client as the plaintiff makes a third-party claim against the defendant's carrier, and then the carrier says, we've declined coverage, they're going to usually give me not, 50-page summary and internal work product, of course, but they're going to deny, and they're usually going to say why. And then it's up, sometimes that's some things that the company really hasn't thought of. Hey, your carrier is not here. Your carrier's declined coverage. How does that make you feel? Does your client think that's correct? Do you think that's correct? Is it maybe time? A lot of times I have kind of sitting in the back benches, I would say, as a consultant, I have one or two insurance bad faith attorneys to basically say, if the other side's carrier or my client's carrier declines coverage, do we consider that to be a rightful result? Sometimes they decline coverage and there's a really great reason. Hey, they haven't been paying their premiums. We don't cover this particular claim. It's a fraud claim. We don't cover it. It's a breach of contract claim on a contractor, and we only cover negligence, right? Basically based on what the policy says. But don't forget that's just a separate contract, and so they can breach the contract too. And so, that's important to understand to the extent that you can. What's the status of that? Who's showing up too? If they've got coverage, if they're willing to tell you, is it just coverage to defend the lawsuit, or is it coverage to actually pay out a claim? They're not going to, they're not going to give you what their max number is, because then you'd make that offer, right? But what their limit to negotiate an insurance if an adjuster shows up on behalf of the company that your client as the plaintiff is pursuing litigation against. But it's important to recognize that you might be able to get some of that information. You might be able to, like I said, understand who's supposed to be there, why are they supposed to be there, what's the status of that insurance, and that can really kind of inform the picture as you go forward in mediation. And I think this last point is extremely important, which is you can always try to save time and expense by starting mediation early with settlement proposals before mediation begins. I think that's extremely a worthwhile endeavor. I find that a lot of times, if we haven't done that, then the first hour of mediation might be doing things that we could have done ourselves, right? The mediator is going to add their expertise and kind of better work the parties along that process, but it's always important. And I'm telling a lot of my clients right now, I said, look, what do you have to lose? The worst thing they're going to say is never, right? Never, and here's our offer, and we're going to inflame your passions. Okay, great. If we can, right? We're gonna upset you with our counter offer, or we're gonna accept you with we're gonna upset you with a rejection. But if you explain that to the client, say like, look, that's the risk, right? The risk is they make a counter that you don't want to counter back, or they're going to reject your settlement proposal. You know, what's necessarily the harm? And I think it's important to recognize that I can say with a fair degree amount of certainty that is what I have seen. When we send settlement proposals back and forth, we may not get there. That's okay. That's what mediation's all about, right? But and sometimes it's easier to do in a commercial litigation dispute than it is in a family law dispute. As I was kind of talking to Alexandra before we got on the CLE, I always am kind of amazed by family law attorneys in mediation because there's so many more extra moving parts. If we're talking about money in a commercial litigation dispute, and I say I want $100,000, and they say I want zero, we both know exactly how much $100,000 is and zero, and we know that the middle of that is $50,000, just objectively. Now, it might not be the middle for the claim, and $100,000 to one person is worth a different value of $100,000 to another, but we all know what those numbers mean, right? We all know what $100,000 is. But if you say, I want, to choose Timmy's therapist, and you say, I want the condo in Aspen, I don't know if that's worth 1/3 of Timmy's therapist. I don't know if that's worth 1/6 of the condo in Aspen. I don't know if that's worth, having, Susie on a Thursday, right? There's so many more moving parts, and it's so much harder to understand what we're talking about in terms of the dollars and cents. And that is one of the ways that commercial litigation can be simpler. But there's also other things, right? Indemnification, the type of release, some of the claims, the non-disparagement proposal, and maybe a tortious interference claim. There's other things that may come in, but at the end of the day, if we're talking about, a set value of finances, right? We're talking about just money. It's easier to explain, and it's easier to make a settlement proposal. It's easier to say, this is the proposal, and here's why I'm making the proposal, and explaining those decisions and explaining where you're coming from in those proposals. And I think that's important too. If you're going to send a proposal before mediation, it's important to explain why you're sending that proposal. I always tell clients, I say, look, we're sending the carrot, but they're not going to feel like it's a carrot unless you tell them what the stick is. So you've got to explain, look, this is why I think that, if mediation doesn't work or settlement doesn't work, this is why this is going to get much worse for you, right? And again, you're talking to maybe a commercial entity, or you're doing a commercial litigation dispute. So what you're talking about is opportunity costs, more exposure, attorney's fees, all those kind of things. You might have to list this on, your taxes, or your filings with your company. You might have to list this litigation if we don't resolve this now. So, those are some things, some potential downsides and some potential risks. And then when you explain those risks, it's important when you do that you're kind of selling the idea of settlement. You're saying, and this is why, I could ask for $1 million later, but I'm willing to settle for $500,000 now if my client's willing to do that. And there's also the time value of money for both parties to keep in mind. So that's one of the ways when you're looking for preparing for mediation: drafting the summary, preparing your opening, discussing it with your client, understanding the status of insurance, understanding who's going to show up on behalf of the opposing party to the extent that you're able to, and then maybe sending 1 or 2 settlement proposals and understanding what the status of settlement proposals were by the time you get into mediation. In all of my files, I have all of my paralegals set up a settlement spreadsheet, and it's just one spreadsheet of all the offers going back and forth and back and forth. So that way we don't have to comb through the file and say who sent the last offer, who sent the last, et cetera, et cetera. Because sometimes that's what the mediator wants to know. Hey, how close have you gotten? How far away were you when you started? How close are you now? When was the last proposal made? Was there a counter made? I mean, those are really important things to keep in mind. And it's really great to have that in a centralized place. That's one thing I'd recommend too. If you're doing litigation, especially commercial, because it's easier to keep track of in an Excel spreadsheet. There's usually not as many factors, right? It's usually, if it's money, it's just the offers going back and forth. It's great to kind of keep that in one centralized location, so you're able to refer to it pretty easily, and you're able to explain and share it with your client and share it with the opposing party if they want it. So attending mediation, making sure you understand the parties at mediation, right? The players. Who's there on behalf of the other parties? What is their relationship to the case? If insurance involved, who's the adjuster, right? Is the adjuster there on behalf of the company or behalf of the insurance company? Because sometimes they have the same goal and objective, and sometimes they don't. And so it's important to recognize who's there, and why are they there? And you, like I said, you can try to get that information before mediation to the extent that you're able to, and just, understanding, why they're going to be there. And it's important to explain to your client why that person's going to be there, and what their relationship to the party is going to be, to the extent that you know. So I just had a commercial litigation dispute, and we knew that the other side was going to have an adjuster, and my client was not experienced and didn't understand what an adjuster was and what they're going to do. So it's very important to explain, look, the other party is going to have a representative there. They're going to know very little about the case. They're not going to be emotionally invested. They are just there kind of as a representative for the company. So, if you're trying to kind of appeal to their feeling and their emotionality of the case, that's really not going to work. And so you have to understand, if they seem more nonplussed about the situation that we find ourselves in, that's not necessarily them being antagonistic. It's just the status of the case. It's just the status of understanding who the parties are and what their feeling could be. I just really haven't had a case, and I don't think many people have, where you have an adjuster on behalf of the company, or be really more on behalf of the company's insurance company, that are a carrier who's really very emotionally invested in the case, who's really been there, day in and day out. They're really more of somebody who's just valued the claim, or talked to their office about valuing the claim, and they're going to just make an informed assessment based on their experiences to tell you what they think the value of the case is. So now let's talk about not concluding representation, hopefully concluding mediation. So if resolved, of course, make sure you get the agreement in writing with the correct signatories. Back to AAA, the authorities, right? We just had a case where mediation or the settlement kind of hit a little bit of a snag, because there was some confusion internally on the other side about who had authority to sign or who was supposed to sign. Make sure you have somebody signing on behalf of the company that's actually, has authority. And how can you do that? Right? Because you're not part of the company, or your client's not part of the company. Make sure, usually with the signatory, there's a title. What's the title of the person? What's the date that they're signing? What's their signature? But really having a title part. And then usually, sometimes in my settlement agreements, I'll have something that basically says, we're relying upon this particular individual, the signatory below. We're reasonably relying upon them to have authority on behalf of the company. That's a material condition of this agreement. Just basically saying, like, this is what all of the parties understand, that the signatories are making representations that they have authority to actually sign this agreement. So you want to make sure that, when you're done with this, just like any other, mediation, et cetera, you're going to want to make sure that you have it in writing, and as fast as possible. Because it's not so much that in commercial litigation disputes, especially with dealing with a larger company, that they're going to walk themselves back from the deal. Right? They're not usually going to get buyer's remorse if it's a larger company. The bigger problem is just going to be the paperwork and the bureaucracy of it all. Right? So you might get the deal done, and then, they've got to, now their adjuster is at a conference or dealing with a variety of other litigation, and it's hard to get them back on the phone. It's hard to get the opposing counsel back on the phone, I should say, and the opposing counsel saying, well, it's hard for me to get my adjuster in place, et cetera. To the greatest extent possible, the greatest extent possible, it is always important to have the deal signed, sealed, and delivered. Have it fully executed in writing by the time mediation concludes. And I get very wary of, sometimes in previous experiences, my naiver days, I would use the mediator. We had a deal in principle and we had it in writing. Now I'd release the mediator before we had the agreement, signed. And I remember this particular circumstance. That's what happened. We had the deal. It was a commercial dispute. I think it was I'm trying to remember. I think it was partially a fraud claim and partially a tortious interference claim with a prospective business relationship. And we were in mediation. We let the mediator go. We had the agreement in writing. We didn't have signatures. And as soon as the mediator left, they wanted to make more red lines. They wanted to go back, and they wanted to backtrack a little bit. We wanted to backtrack a little bit. And then we were there in the conference room for another 3 hours, where, if a mediator had been there, we probably would have been there for another 10 minutes. And so I think it's very important to recognize that until you have a deal signed in writing, you don't have a deal, right? You probably have an agreement in principle. Maybe you could ask the court to enforce it, but the whole point is, why do that? Why just make sure you have the agreement in writing. And because you're dealing with commercial litigation rather than family law, right? And if in family law, you got the two spouses, the husband's got to sign it, the wife's got to sign it. Commercial, you need to make sure that somebody with authority, to the extent that you can, is actually signing that thing. And finally, if it's not resolved, so that's resolved, great. You've got a signed, sealed, and delivered. You've got an area and a place in the agreement where a signatory can actually sign and show that they have authority to sign. Now let's talk about if it's not resolved. It's still important, even if your client has experience in litigation, right? They're the commercial entity maybe, and they've dealt with wins and losses. It's important to talk to your clients about the new risks and costs coming with protracted litigation. Or if, say, your client's the plaintiff, right? And they're they just found out the case is going to be impasse. It's important to explain to them, as you've been doing throughout the process, communicate. It's important to recognize and discuss with them the additional cost of that, right? It's a little bit of a David and Goliath, perhaps. Maybe, it's a big company, whatever kind of company it is, and your client's, kind of a, by themselves. Maybe they're just an individual or they're a smaller LLC. It's important to explain, the added cost of that, especially if your client's not being represented by insurance. If their client's being represented by insurance and your client's not, they've got somebody bankrolling this, right? Who's financing all or a portion of that litigation. It's important to recognize and tell your client, you're going to feel the sting of the finances that are attributable to this litigation more than they are. Their insurance is there to pick up all or a portion of the tab. And it's important to recognize that when we're talking about the litigation costs. And don't get discouraged, right? Because just like any other mediation, it's not a situation where mediation may resolve right then and there. There are many cases that I can see some people on this call, I'm sure, that have had these experiences, many a case where, you conclude mediation and it impasses, and a week later, a month later, due to the conversations that you first had at mediation, you now have a resolution. Right? So it's important to recognize not to just get discouraged by the process, and to explain to your client throughout the process. I always say, look, litigation, especially in the commercial process, but really in all litigation, is very formatted and regimented. There are specific things that you have to do, except for one thing: settlement. Settlement, the sky's the limit. You get to be creative. You get to work off different timelines. It's, if you have a motion for summary judgment and it's granted, and you're the opposing party, you don't usually get to go, hey, let me get a second bite at the apple, right? Like, I didn't like how that motion turned out, Judge. I'd like a second bite at the apple. I'd like to continue this. I'd like to, refile the motion. Probably not going to happen. But in mediation and, really settlement after the fact, it's important to recognize you can always do that. You can settle early and often. Well, not often, but early. You can settle throughout the process. You can make settlement proposals early and often. And I think there's a lot of different reasons for that. One is to actually settle the case. But if you don't, and one is to understand the position of the other party, especially that's one of the other reasons to send a settlement proposal before mediation, right? You want to understand, where's the other party coming in? We just sent a settlement proposal in one of our cases. We got a response wildly off base. Like we think it's completely not where we thought that a proposal would be coming from. That's great. That's still great. There's still value to that. It's not great because we're not going to solve the case right now, but the whole point is there's a value in that, because I now get to pick up the phone with the opposing counsel and say, I'm really not understanding where you're coming from. I thought we were getting closer here, and now I think we're taking a step back, and let's take a time out and understand that, right? Like, I want to understand, if you're making a proposal or you're making a counter, where it's coming from. Where are you coming from? And that's really something important to understand throughout the litigation process, throughout the settlement process, and throughout, concluding mediation. So it's just important to understand and to talk to your client. And really, I think it's just important, a day or 2 days after mediation, to check in with your client, especially if they're a smaller LLC. This might be their first litigation or their second litigation. Maybe they haven't had a case in 5 years, and really just kind of, check in, because they're going to be going through a lot of feelings. After trial, after deposition, after mediation, that's the time where your client has been exposed to the most that it's going to be exposed at a specific time period in litigation usually, right? There's a lot of things that have happened in their case very quickly. There's a lot of information that's been shared. I always tell clients, you can't lose mediation. You can either win by settling, or you can learn. You can learn more. You can learn more than you could possibly learn in 3 to 6 to 9 months in your case. And that's really important for clients to understand on the front end, because you want your clients to see a value in mediation, even if it doesn't resolve. And one of the two ways that happens, because otherwise right? Even if it's a small company, they're going to come back to you and they're going to say, I don't know why we did that, right? That was super expensive. We hired this mediator. I don't think they did a great job. And I'm upset and I'm stressed, etc. But if you talk to them, not all the time it will work, but if you talk to them beforehand and say, look, this may not work, right? We may impasse. But what I expect to get out of that is you're going to learn, you're going to understand their position better. You're not going to like it, but you're going to understand their position better than you did walking into this mediation. And we may not resolve this at mediation, but there might be reasons why that conversation keeps coming back to try to come to a resolution. And especially if you were close, maybe you finished the mediation and you were, 25, you were just really close based on the scheme of the amount, right? You were, 25%, 20%, the delta was 10% between the two parties. That's a reason to keep the mediator involved. Just because mediation comes to an impasse doesn't mean the mediator is not there for you. I've found, especially in Lee County, the mediators are very, very helpful, and they're there for you, and they're there basically if they know, hey, we were really close, and you just can't seem to get it across the finish line, maybe a week or month afterwards, give them a call. Say, hey, look, I know we were really close. Can you kind of back channel for me and figure out, what it is that gets us across the finish line if we're close? Look, if you have a big delta, you have, and you're, a really, really large amount that you guys have to get across, maybe that's not as valuable. But I think especially if you're, fairly close, it's important to do that. And it's always important, like I said, to key in with your client, communicate after the fact, say, well, how are you feeling? How do you think that went? Just really want to discuss that, because that's one of the times where they're going to want to talk. They're usually going to want to talk to you about what that process was like. Maybe not on an adjuster side, right? If your company, the larger your company is, the more experience that had with litigation, the more likely that conversation is going to be short. But it's just really important, if there's been an impasse, to talk to your client and understand how they're feeling about the process, after the mediation has concluded. So with that, that is my presentation. I will stop my share and I will take any questions if we have any.
Well, first of all, thank you so much, Joey. That was really fantastic. We so appreciate you giving us a perspective from the attorney side. A lot of us are attorneys and mediators, so we sometimes experience both sides. And as a mediator, of course, we look for different things than an attorney to go into mediations. So I do appreciate you actually wanting to have a signed agreement. And normally what we try to do is also not leave before anything is being signed. If it's really close to, it's just a matter of, okay, we have the agreement, it's written up, we just need the signatures. So let's go on and have it signed. And nowadays it's so much easier with the electronic signatures. So it shouldn't be too much of an issue nowadays anymore. And at least I always tell the parties, if I don't have any signed agreement, I have to mark it as an impasse and that there was no agreement. So I know parties want to settle, so that should be an incentive for them to actually sign it while we are still in mediation.
Well,
I think they usually want to. It's more, just, an attorney, maybe it's 5:05 and it's a Friday. And, I mean, if you signed up for mediation, I think you both explained to your client, look, this can drag for quite a long time period, and also being prepared to do that. If I have a mediation, whether it starts at 9 or 1, I tell my office, like, I'm not going to a LCBA event that night. I'm not, or if I am, I'm canceling it and I'm ready to cancel. I don't have anything that I can't cancel or reschedule that night, because, I've been in mediations that have only taken 4 hours. I've had other ones that drag on for 7 p.m., 9 p.m., even in, commercial litigation disputes. So you just have to be prepared to basically be there until you have the signature on the dotted line.
And Joe, this is Ann Dalton. First, I want to thank you very much for the presentation. It was extremely informative and detailed. It's wonderful. Thank you. But I do have a question. Do you pick a mediator based upon what you believe their expertise to be, or would you rather have a mediator that has general knowledge and doesn't have expertise in your particular litigation?
Both. Well, it's usually my decision on choosing a mediator is sometimes informed by 2 factors. And that's just personally for me. The first one is based on, the particular industry of the practice. I've got one right now where it's super specialized. And so we literally went hunting for like the 3 people in Florida that I thought could be best suited for it. So I might look for someone, who works in that particular industry. But the other thing is, so then you've got a couple that have familiarity with the industry that you're involved in. But the second thing is also their temperament. Mediators have different temperaments, and that's not a bad thing. I think it would be a disservice to the community if all mediators were the same. And so there are definitely some mediators where, I say, hey, I really need someone who's going to beat up on my client, who's really going to, yeah, I've tried, but maybe I don't have the best client management. And so I'd really love to have somebody who can be there and is going to hold their own and explain their position. And really I've done it, but I need a third party to do it too. I have other ones where it's, I had one today, I know we're going to go to mediation. And the whole point is I just need someone who says, I don't care about the facts. Here's the bag, put the money in it. Right? Like basically says, look, I don't really want to spend a bunch of time evaluating the facts or going through it. Because we could, but it's just one where it's just a morass of facts. And the whole point is, at the end of the day, I just want, it's a different mediator for a different temperament to say, I don't really want to get into the facts and circumstances at all, though we could, and I think our client would prevail. I think it's more, let's just try to figure out how to make a deal. It's just more dollars and cents. So there are a variety of different mediators with a variety of different temperaments that we have experience with that kind of suit themselves better for particular circumstances. But one of the things, yes, and definitely the industry, not particularly the specific industry, but and sometimes yes, depending on how specialized it is. But that is something to sometimes look at, especially like, for example, that one case I was talking about, construction defects. Usually want someone who this has been, there, if I talk about underlayment or I talk about a dry end, we're going to kind of be able to talk pretty quickly and kind of walk through some of those specifics.
Thank you. That's very informative. I appreciate that.
You're welcome.
Thanks. And I also think it's very good that you prepare your clients for mediations, because I've seen other attorneys that basically don't tell the client anything about mediation. And you as the mediator are then left to explain to that client what is happening here right now and then. And you're just looking at the attorney and thinking, okay, why didn't you do your job? Why do you have the mediator explain everything? That takes away a lot of time. It's not really, in my opinion, the mediator's task to do that, but the attorneys.
Yeah, it is. And I think there's 2 things that, well, first I explain the mediation process, even if this is their first mediation or their 100th mediation, right? We have a mediation Zoom, like we talked about the Zoom issue, if we're doing it via Zoom, and we talk about the process and just kind of the mechanics of it all. The other thing I usually like to do, and I say you don't have to tell me, but give me your optimum number. Give me your rainbows, your, where we're going to start on Monday and why, or where we're going to start on the mediation and why, right? So that I'm prepared when we go into caucus. But I will never ask them what their bottom line is. And the reason for that is because then they're going to get entrenched. If their bottom line is $50,000 and the other side comes up with 48.5, they're going to fight you on it more than they would otherwise. So I never want them to think this is what I'm willing to offer or walk away, because you don't want another offer to come in and they say, well, that was the bottom line we talked about. They can have those thoughts, but I don't want to do anything, especially before mediation, to say, let me help you get entrenched in your position. I just want to say, where are we starting? Understand we're not going to get that, right? Tempering those expectations, understanding they're going to make counters and we're going to have to counter. And then, asking them if they have more questions about it, and then taking it from there. And really just saying at the end of the day, it's not about what makes you happy, it's about what makes you comfortable. And I think that they get that. They do understand that. And I think that that's really can be a very helpful thing, because there's a value add to closure for everyone. Companies, it's closing the books, right? Hey, it's off our balance sheet. We don't have to report it on a K1, or we don't have to report it on our filings, right? Like we're done with it, right? We don't have to pay attorneys for it. This line item's gone. from a financial perspective. Even for smaller companies, either individuals or smaller companies who find themselves in commercial litigation, there's still a value to the closure of it all. Just to basically say, like, look, I don't know what the value is. That's your job to tell me what you think to put a dollar on it and to tell me what you think it is. But it's not believable for you to say that there's no value to closure. There's a value to closure. There's a value to peace.
Right. Well, we very much appreciate you, Joey, for taking the time and speaking to us today. I don't know if anybody has more questions. I'm pretty sure you're always available, as you mentioned. So if anyone of us has questions, I'm sure Joey is willing to answer. And I just want to also wish everyone happy holidays, Merry Christmas, and all the best for the new year. We are working on an exciting schedule for next year, so stay tuned and we will be back, yes, next year, I guess.
Well, thank you so much for having me. Yes, Alexandra and Lauren have my contact information. It's Coleman Litigation, jcoleman at colemanlit.com. Lit is in litigation, but she'll share that if you need it or want it. And happy to chat and happy to discuss anytime. And I really appreciate the section asking me to present today.
Well, thank you. And again, also thank you, Lauren, for reminding us to pay our fees. That's very good. I always need the reminder. Thank you.
Always happy to remind people to get some money into us.
That's perfect. Thanks, Lauren. Well, everybody take good care. And if I don't see you this year, then next year. Bye.